Good morning and welcome to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. I am located at 1563 Main Street in Peckville, Pennsylvania, and I am right here at this time on this station every Sunday from 8 to 9 a.m. to bring you, the landowner, the information that you need regarding natural gas development here in Pennsylvania. And this seems like a good time to remind you that I, Doug Clark at the Clark Law Firm, represent landowners, gas right owners. I do not, have not, and will not represent gas or pipeline companies. I represent landowners, property owners, royalty owners for such items as, of course, gas lease negotiations, reviews, and consultations. You hear me talk about that a lot. If you are signing a document provided to you by a gas or pipeline company and you've not had a review and consultation with an attorney, whether it be me or someone else who knows what they're doing, I think you're making a mistake. And there's a lot of people out there that have unfortunately done so already and have made some major mistakes. So again, if you're going to sign any document presented by a company, you should have that document reviewed by an attorney who knows what they're doing, who is working for you and can help you out. I'm going to touch on again today a little bit the multi-unit well requests that are going around all over Susquehanna County, provided by Cabot. I'm going to talk about some releases today, release documents for well pads in Tioga County that has me nervous. And we're going to talk about some other things as well, but just great examples. If you're given a multi-unit well document, if you're given a release, pipeline agreement, gas lease amendment, modification, you need to, at minimum, have a review and consultation, and you may need additional representation. You can always contact my office. Again, you hear me say these reviews and consultations usually only take an hour to two, and with the multi-unit well issue, it usually takes about an hour or less. You need to get this information. So you can always call us 570-307-0702. Again, at Doug Clark, the Clark Law Firm, 570-307-0702. Also, we're doing a lot with the royalty issues, unitization issues, potential breach of contracts, well pad, you name it, related to oil and gas, buying and selling properties in the oil and gas. Boy, if you're thinking about selling your gas rights, selling property in the oil and gas region, again, I'd really encourage you to give us a call, have a review and consultation, and just learn what you need to know if you're going to go down this path. Learn at the beginning. Don't learn at the end. And of course, do not let, especially these companies, but do not let the person or company who's buying your oil and gas rights to be the one who's going to educate and inform you of this process, who's going to be the one who drafts and supplies you the documentation for the transaction. Many people have had very bad experiences in that process, and you need to be protected. So look, love to hear from you, whether you call us, call someone, but do not just simply go into these transactions without having representation working for you. You need to do that. Many times it results in more money, but even when the attorney can't negotiate better compensation or better price, they can typically almost always negotiate better language and contract terms. And again, I'm not going to go diving too deep into these transactions today. We've talked about them before, but there's things in there that you need to be careful of. You need to be mindful of. Every time I've talked to somebody who was going to sell oil and gas rights, they've been very pleased at the result of that conversation to understand more, again, what you need to know, and understand how the company who wants to buy your oil and gas rights are drafting these documents for this transaction, for this sale. They're drafting them in a way that's very advantageous to them and not to you. But of course, that's what we would expect. They are out for themselves. You need to protect yourself. So again, you can always call us 570-307-0702. If you're looking for representation in any of these areas and others, we'd be more than happy to talk to you and see if we can help you out. This is All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm, where I represent Pennsylvania land owners, gas right owners only, have not, do not, and will not represent pipeline or gas companies. So, okay, like I said, I want to talk about some documents here today. I touched on this recently, but boy, if you're in Susquehanna County and you're leased to Cabot Oil and Gas, you probably have had a letter, or you may get one soon, but boy, a lot of people have received them, where Cabot is requesting your consent to drill what are called multi-unit wells. So they send you documentation in the mail, then they ask that you hurry up and sign it and return it within 30 days, and then you have to understand what it is that you're presented with. And do you need to sign it? Why would you sign it? What are the benefits to you to sign it? What are the detriments to you to sign it? Think about if you're a company and you want someone to sign a document and you send it to them and you know that there are some potential advantages or benefits to the person to sign, but of course maybe there's some negatives for that individual to sign as well. But you work for a gas company and you're tasked, or your job is to get people to sign these agreements. So when you talk to individuals, and I'm just talking hypothetically, this isn't about any specific company really, but it's the same with any document. So when you go and you talk to the property owner, you talk to the gas right owner, and you say, hey, we want you to have to sign this document. The landowner says, well, why do I want to sign this? What's in it for me? Well, then there you go. Company guy says, well, we're going to do this, and it could result in you receiving more royalties. And of course, usually it's going to be representing that you're going to get a lot more money. Future riches, future royalties, sign. It's going to be good for you. We're going to get you a bunch of money if you sign. Well, let's look a little deeper. What are the potential negatives for you? You're listening to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. Well, I've been waiting for this case, and I just had a review and consultation on a multi-unit well consent request in Susquehanna County, or a landowner from Susquehanna County. And the exact situation that I have been watching out for and waiting for appears to have occurred with this person in our review and consultation. And what do I mean by that? Well, it gets really complicated, so I'm going to try to simplify it. But the point is, so landowner gets a request to sign this consent to multi-unit wells, or for multi-unit wells, which means that the company wants to drill much longer horizontal wells. So, for example, maybe the company, if there were normal circumstances, might drill a horizontal well that was 5,000 feet long horizontally. However, if landowners sign these consent forms and the company decides that they want to drill longer laterals, they may go, instead of only going 5,000 feet and produce gas from the unit where the lateral is going through, 5,000 feet worth, well, maybe they'll make that lateral go 10 or 15,000 feet, or anywhere in between or longer, but they have the ability to drill much further out, much longer. So they say, hey, that's going to mean less well pads. So, hey, property owners, that's good, less well pads. Well, company, that's good for you too, because those well pads cost a lot to build, so that's good for you too. Also, in drilling the wells, if you can drill a well longer, instead of drilling 3 5,000-foot wells, if you can drill one 15,000-foot well, then that's going to be more cost-effective also. You don't need to also bring the rig from one location to another. Again, having to construct multiple pad locations, permitting, all of those different things come in. So it's a pretty big benefit for the company as well. It can also benefit you as a landowner, but it's going to benefit the company too. And don't lose sight of that fact, because the question becomes, okay, well, company, you're going to get a lot of this, a lot of benefit from this. What am I going to get? And that's what you need to ask yourself. And then need to say, okay, well, what is the benefit of me going to sign if I sign? But then also, is there a detriment? What's the negative if I sign? Or what's the negative if I don't sign? So we need to look at this in every possible way. Likewise, what is the negative if I do? What if not negative if I don't? And then the same thing the other way. What are the positives if I do, and the positives if I don't? You're listening to All Things Marcellus with me, attorney Doug Clark of the Clark Law Firm. So let me kind of clear this up a bit. So, landowner is asked to sign this consent form. Well, in this particular case, and again, this is going to boil it down, but in this case, it looks like strongly that if they do not sign the consent form, most likely, again, this is how it appears. I'm not saying this is a guarantee, but this is how it appears from this review, that most likely, if they do not sign the consent, their lease will most likely expire this summer. And their existing lease that would expire this summer, it looks like it will if they don't sign the consent form. And this is a unique situation. This isn't for everybody. This is just an example. But if they don't sign the consent form, their lease probably expires, which means that they get to attempt to negotiate a new lease if their lease expires, if the company wants to drill and produce in the area, and of course we know that they do. So if the market is, let's pretend the market's $1,000 an acre now. Let's go hypothetically that this person owns 100 acres. So if their lease expires this summer, as it appears that it will, then they would be eligible to negotiate a new lease. And so if they have 100 acres and they can negotiate a new lease at $1,000 an acre, well, you guessed it, they just made or got a bonus of $100,000. It appears probable that if they were to sign, or let's even say maybe, if they were to sign the consent request, that their lease may not expire, which would mean they would not have the ability to try to renegotiate or negotiate, not even renegotiate a new lease. And again, we are using the number $1,000 an acre bonus for 100 acres, meaning $100,000. So, in my opinion, in this particular instance, it would be a textbook example of a person who should not agree to sign the consent form. But this is a particular situation, and different people can be in different situations. Literally, this person's neighbor could have the same original lease, same terms, same language, and if they had a couple acres that were already in a unit, then that person may be motivated to actually sign the consent form because it might encourage additional drilling that would benefit them. Now listen, the key is you have to look at this in your specific situation, because these types of consents and many other agreements, almost all of them, but you have to look at your situation. This person, my opinion, my example, absolutely should not sign the consent form, but their neighbor could have the same exact original lease. They could have signed the same day at the same kitchen table, had the same lease, had the same 100 acres. But if the neighbor has 100 acres and 5 of their acres, and I don't care if it's 1 acre, 5, 10, whatever, if some of their property is in a unit, but the other neighbor doesn't have any property in the unit, well, those two people may make two different decisions, which would be quite reasonable under those circumstances. Again, the key here is, what are our takeaways? Number one, stop simply signing agreements. If you get something in the mail or something presented to you, get some assistance. Again, I do these reviews and consultations all the time. We do them by telephone. We do them in person, whatever you'd like to do. You send the documents. I review them. We do the call, you and I, your family and I, whoever it may be. We go over everything, answer questions, offer suggestions, even recommendations, and then you make your decision. Again, whether you go through that process with me or someone else, you should do that. Then the next thing is, you need specific advice for you, not simply just general advice or general information. Or, hey, my neighbor signed, so I'm going to sign. My neighbor does a lot of, he's always on the internet, she's always on the internet reading about oil and gas, so they sign, so I'm going to sign too. Well, no, you can't do that. Just like this person whose lease may expire this summer, if their neighbor signed and they said, oh, well, my neighbor, they're really knowledgeable, and they signed, so I'm going to as well, they may have cost themselves right off the bat $100,000, maybe, again, hypothetical situation, but also their original lease, let's say, was 12.5% and allowed full deductions for post-production costs, and maybe if their lease expires, maybe they can get higher royalty than 12.5%, and maybe they can eliminate deductions from their royalty statements and checks for post-production costs. Boy, that's a big difference. So, a call in that scenario, a review and consultation, and this one took less than an hour, probably, or may, I'm not saying I can't guarantee this, but boy, if it does, you're talking about hundreds of thousands of dollars of benefit to this person over the course of a new lease. So again, I want to summarize again. Look, this is based on a true story. It's a hypothetical, changed a lot of the facts, so we're not getting too specific. But the idea is not to give anyone specific advice other than to get specific advice. But the idea is to understand that everyone could be in a different position and that everyone should stop signing agreements that are presented to them and get advice, because an hour or two of time may have a tremendous impact on you for literally decades upon decades. You're listening to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. So look, again, Susquehanna County landowners, Cabot multi-unit well consent forms. Give us a call, 570-307-0702. Get the information that you need to have in order to evaluate the multi-unit well consent requests. Not the information that the company is going to tell you that they want you to have. Get the information that you need to have. And that information very well may ultimately lead you to say, hey, I'm going to go ahead and sign this. Or it may lead you to say, well, I'll sign it, but I want to add a couple other terms or conditions. Or it may lead you to say, oh, thank heavens, I'm going to put this away and not sign it because my lease may expire, and I absolutely want that to occur because I think I can get a better lease today than what I was able to get in the past. The key is specific personal advice, and you can get that from us at 570-307-0702. Learn about reviews and consultations, 570-307-0702. Join me right here, All Things Marcellus, every Sunday, 8 to 9, but we're not done. This is section 1. I'll be right back after this break. Welcome back to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. Remember to join me every Sunday right here in this station from 8 to 9 a.m., where I bring you, the Pennsylvania landowner, the information that you need regarding natural gas development here in Pennsylvania. Okay, so I want to talk about releases. Okay, a release is a document that is presented in exchange for what happens is generally speaking, you as the landowner would be receiving compensation or money in exchange for activity that may have occurred on your property. For example, just this is another example of a release just to kind of set the stage. So if there was a car accident and two people got into a car accident, and let's make it a minor one, and say that the one car had, we'll make it too minor, we'll say $5,000 in damage to the one car. It was clearly one person's fault. So the person whose fault it is, their insurance company is going to pay the other person $5,000 to fix their car. Well, they don't just give you $5,000. They say, here is $5,000. We want you to sign this document called a release. And what this document is saying is, in exchange for this $5,000 we're going to give you to fix your car, you can't in the future come back after my insured, the driver of the car, or us, the insurance company, and say, hey, wait a second, actually, my car was $7,000 to fix. Or actually, I also hurt my arm, and I didn't realize that, or I hurt my back, and now I want more money for that. No, what happens is you're going to be presented with a release in order to get that $5,000 to fix your car. So that's what a release does. It releases the company who's paying you, or the person who's paying you, it releases them from future liability. So, hey, we're giving you this money. You can't come back and claim or complain later. Reasonable thing, except the release language has to be reasonable for you to sign it. You should not sign an unreasonable release where you're releasing claims, potentially future claims, that you have no business releasing today because you have no idea what's going to happen in the future. Now, you can certainly, in cases when it's appropriate, release future claims. Let's go back to the car accident. The guy who's getting $5,000, he's going to get the $5,000 and he's going to release future claims where he's not going to be able to claim, well, no, in second thought, it's $7,000 you owe me. No, you've released that ability to do that. However, in oil and gas operations and other activities, these releases aren't all the same. And so if you say there's going to be a well pad, and we're going to talk more about this. You're listening to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. So we're talking about a release, and let's say that a company puts a well pad on your property, and they say, hey, we want to give you some money. Here's a release. You better darn well read that release and understand what it's saying. Should you, if the company is going to pay you amount of money for the damages to your property, the surface damages to your property for placing a 20-acre well pad on your property, they're going to give you some money. Should you release them from all future liability? Or should you say, in exchange for the money you're giving me, company, I will release you for the damages that you've done to my property as of the date that I am signing this document? I am not going to, I do not want to release you, company, for any potential future claims that may arise from your operations from this pad. There often are times where there's a lot of things that are cranking in the back of the minds of the company as to why they're doing something, and you'll never have any idea why. And so one of the things that I have some concern about is in the Tioga County area, we're seeing landowners who have pads on their property, well pad on their property, and that pad has never had any wells drilled that are producing gas. So let me set this stage for you. Again, you're listening to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. So we have a pad. Let's go back in time. Let's get in our little time machine, go back to 2010 and say the company, whether it be East or Shell or Sweppy, they create a pad. They construct a pad on a person's property. And then, because they want to hold the leases, because they're very company-friendly leases in a lot of cases, they drill a vertical hole straight down, vertical, straight down. They don't turn it and go horizontally. They just drill a vertical hole. And then they cap it. They put a cap on it. And they say, okay, we've drilled a well, they say, capable of producing gas. Ironically, many and not most of these, you'll never see a drop of gas come from. But they say, we've drilled a hole where you can produce gas. It's capable. We're not. We just have it shut in. Then, now stick with me here. So now, here you have a pad, and maybe you have a well, a vertical well that's drilled and capped. Now, the company wants to construct another pad close to the first one, but they want to construct another pad, and they're going to drill from the other pad. Well, why are they doing that if they already have this one pad? Well, maybe, my thought, maybe the company never ever really intended to drill from the first pad and produce gas from that. They just wanted to hurry up, get a pad in place, drill a vertical hole so they could tie up leases, and these leases would not expire. Now, when they're getting serious about drilling horizontal wells, they say, that pad that we maybe rushed just to get into whole properties, that's not actually where we want to drill from. And maybe that's a smaller pad. We need a bigger pad, all kinds of different reasons. So they say, okay, we're going to ultimately reclaim that original pad, and we're going to create another pad very close somewhere to the first one, and we're going to actually drill horizontally off of the second pad. Well, if you're the first guy, you may not be too happy about, and you probably aren't, and nor would the people around them. But hey, you designed and you constructed a pad on my property, and you drilled a vertical well. You never produced any gas from that well. I never got any royalties. Now you're knocking on my door and telling me you're going to reclaim or get rid of this pad on my property. You're going to put a new pad somewhere else, maybe on my neighbor's property, and in some cases, maybe somewhere else on my property. So I have a pad that you're really not going to use on my property. You're now coming to me and telling me, hey, we're not going to use that one. They're probably going to say, oh, we can do much better over here. But you're going to put another pad on my property. So now I'll have two different pads, but you're going to reclaim the first one, but I'm going to have had two pads of activity, and I'm going to be pretty mad, I think. I'm not going to be happy. If that's me, I'm not too happy. You're listening to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. So we're talking about, again, we see this you don't see, I haven't seen this anywhere else. I've only seen this in Tioga County, where a company builds a pad, then years later says, well, we're never actually going to produce gas from that well pad. We're going to make a new pad somewhere else, and we're going to reclaim or close up the first pad. Well, what are we going to do? Well, what if this landowner sues us? What if they complain and say, wait a second, this wasn't done properly? And again, this gets very technical. You need to get specific advice. But as a company, you're always looking to say, how do I defend myself from a landowner who may make a claim that I didn't do something properly? Well, let's circle back. How about let's have the landowner sign a release. And let's have them sign the most broad, comprehensive release that we can, so we can avoid having any potential lawsuits against us in the future. You're listening to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. Join me right here in the station every Sunday, 8 to 9 a.m. So the company is clearly motivated to get the broadest release possible. And I'm going to make a direct call to people out in Tioga County. If you have a release or you have a well pad that has a vertical well that has never produced gas, and you're given a release, man, I would like to hear from you. Same thing, though. In that scenario, that's a very interesting situation because I question, again, my opinion, whether everything was done properly. But I also am very concerned about people who may, I stress may, have future claims, give them up because they signed an overly broad release document that they, in my opinion, shouldn't have signed. And why would you sign it? Because these things are often complicated to read. They're full of legalese. And the company is saying, oh, here's this release, and I have a check. I can get you this check today. I'd like to get you this release signed. We'll get you a check today. We'll get it to you within a week. Well, it's taken a long time. Now, all of a sudden, this is the situation. Well, again, I would say be cautious. Be very, very cautious and stop simply signing releases. We have to just stop signing releases. Get a review and consultation by me or somebody and find out, should you be signing this release? May you be giving up future claims? I'm still, again, very interested to watch how this plays out, where we have Sweppy out there in Tioga with well pads that they're going to reclaim and construct new pads, sometimes on the same property or next door. And, was this all appropriate? Was this done in an appropriate fashion? And that's something, we're looking into. So keep that in mind and don't simply sign releases. I would love to hear from you at our office, 570-307-0702. But if you don't call me, call someone and find out, what am I giving up if I sign this release? When we get to the next section, I'm going to talk about specific release language. Again, even if you're not, so we don't want people tuning out because they say, I don't have a well pad in my property. Look, same thing applies for everything. Anytime you have a release document presented to you, you need to pay attention because you are, by the nature of the document, releasing, giving up rights. And you better make sure that what you're getting, the money, the compensation, the consideration, what you're getting justifies what you're giving. What you're getting needs to justify what you're giving. And as you may expect, it doesn't always happen. We'll talk about language when we get back. Next section, you're listening to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. Make sure you join me every Sunday from 8 to 9 a.m. right here in this station. And remember, talked in the first segment about multi-unit well consent forms that are being sent and have been sent to many landowners in Susquehanna by Cabot Oil and Gas. I would really encourage you guys, that's the case, give us a call, learn about the reviews and consultations we're doing on these documents. Generally, it takes less than 1 hour. You send me the information, I review it, we set up an in-office or telephone conference call, we go over everything, I explain it, I explain why it may be good or bad for you, I offer my suggestions and recommendations. Usually takes less than an hour, and I'm telling you, I think that the person who we just did one this week, boy, I think they're not going to sign. I think ultimately their lease will expire, and I think it's going to be very, very profitable for them. That's what I think. Time will play this out, but not saying that applies to everybody, but the important thing is get information before you sign. Why would you just sign a document that's sent to you in the mail without learning what it is from somebody working for you? So you can give us a call, 570-307-0702. I'll be right back after this break. Welcome back to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. Remember, I'm here with you every Sunday from 8 to 9 a.m. right here in this station. And again, if you have a Cabot multi-unit well consent request mailed to you, presented to you, I would encourage you to give us a call, 570-307-0702. 0702. Doug Clark, Clark Law Firm. Learn what we do. Learn if we can help you. Reviews and consultations have proven to be very valuable on this subject. And that's the same thing, whether it be pipeline, gas lease, new gas lease, amendments, modifications, you name it, oil and gas related. Give us a call. See if we can help you. Love to try to do it. Love to help people. That's what we do. That's what we want to do. We represent landowners, oil, gas right owners, not companies. Why not? Because we don't do it. Have not, will not, won't. All right, let's get into it. So, okay, we're talking about the release form. So I'm going to go through. So here's some release language. And I talk about it having a lot of legalese and being difficult to understand. So in this case, it says, upon tendering payment of blank, we, the owners or tenants, that being you, of the above described land, hereby release and forever discharge the company, its agents, its contractors. So you're releasing and forever discharging the company, their agents, their contractors, subcontractors, affiliates, and their successors and assigns of and from any and all causes of action. So any and all causes of action, lawsuits, any and all causes of action, any and all debts, claims, demands, damages, covenants, liabilities, and suits of any nature or kind as they relate to, arising directly or indirectly out of, or, boy, it gets tiring, huh? Out of or as a result of the limit of disturbance created from the construction and operation of the blank well location. So it would say the name of the location. Well location and access road as described in the attached draft site plan. Which, now here we go, which we may now or hereafter have. So which we may currently have any of these claims and all these different things we're releasing, or what we might have in the future. So let me stop there. I know that's a lot, and I'm not going to bore you again with going back through all that, but the point is look, you're releasing everything from today or that you may have in the future. Well, who knows what you may have in the future? Is that what you want to release here? The other thing you got to be careful of, if you're releasing today for something that is not yet even started or occurred, you may want to be careful. Not saying we don't do this on occasion. Not saying we wouldn't necessarily do this here, but boy, we want to be careful and we want to understand what we're doing. But when we're talking about also, and remember, I'm talking about people in Tioga County where they have a pad and a roadway on the property. There was a well drilled, just a vertical well. It's capped, and now the company actually never intends on using that well pad again. And let's say you've never signed a release for that existing well pad. I would be, not specific advice, get specific advice. But generally speaking, boy, you should be asking a lot of questions because maybe there is something there. Maybe there isn't, but maybe there is, where a company just uses the property in order to hold your lease and the other ones around you, but never intended to develop and to produce gas from the well site that was created and constructed on your property. And that interests me. That interests me. Again, I'm not telling you any conclusions here. I'm telling you that interests me. And not specific advice, but I would be very slow in signing a release for an existing well pad if I thought for a second that pad was not going to be produced from, or it's going to be reclaimed, because you might be giving up claims. Maybe you don't have any claims, but you might be giving up claims. So these are things that need to be dived into in detail for your specific case. But one thing we know for sure is people need to stop signing releases with gas and pipeline companies without having those documents reviewed by an attorney working for them. You are then, if you don't do that, you're relying on the company to draft a document that you're going to release claims in exchange for money. Well, you better darn well think they're going to release every single thing under the sun. And in a lot of cases, you're going to want to try to narrow that release. And in many cases, you can narrow it. So that's the information that you need, and you need to get specific advice. So we're always available. Learn about reviews and consultations, 570-307-0702. You're listening to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm, and you can join me right here every Sunday from 8 to 9 a.m. on this station. And I remind you again, multi-unit well consents with Cabot. You have one of those. You want to do a review and consultation, you give us a call, learn about what we do, see if it's right for you. Usually takes an hour or less. Send us the documents, we do the call. Give us a call, 570-307-0702. We have to stop just signing documents. We have to become informed and do the best we can, because many times there are opportunities. Maybe there may not be, but many times there are. We have to just stop signing documents. I also want to remind everybody, we do the shows on the weekends, but we post this weekend's show, and it'll be up and available on the websites. So I want to remind everyone, if you haven't gone to the websites, our website, it's not like this a lawyer, typical law firm website with some just general information. You can go to the websites, read, check them out. There's a lot of great information out there. Educational, informative information, not designed as specific advice. Neither is the radio show, but the websites get you thinking. Things that you should be thinking about. We have 10 common mistakes. A lot of information on the websites that if you have not been there, you really should go and check them out. The websites are pagasleaseattorney.com, and then it's our sister website, pipelineattorney.com. We post the weekend show. So this show will be up and available on Monday, that you can go to either pagasleaseattorney.com or you can go to pipelineattorney.com. You can listen to the entire show anytime you want. So if you can't join us on the weekend, you can just tune in during the week and listen anytime you want on the computer. Anytime. Take advantage of it. We also index the shows so you'll know the topic of the show. So if you're interested in a multi-unit well consent, or if you're interested in release forms, then this will be a good show for you. But if you're interested in royalty and royalty deduction issues, you can scroll around there and find many shows and check them out as well. So I've been doing the show. We're closing in. We've been doing the show since 2010, so 7 years in doing the show. So, wow. And we're not stopping. So there's a lot of shows. We don't have them all archived back 7 years, but there's a lot of shows available. Where can you find them? pagasleaseattorney.com, pipelineattorney.com. Check out the websites. Great resource for you, the landowner. All right, we're going to wrap up this section here. We got one more to go. You're listening to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. Join me right here every Sunday, 8 to 9 a.m. Give us a call, reviews, consultations, any representation, 570-307-0702. I'll be right back. Welcome back to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. Remember, join me right here on this station each and every week at this time so we can get you the information you need regarding natural gas development. Also, I want to remind everybody, I'm talking about multi-unit well consent forms today. We're also talking about releases. Those are kind of somewhat narrow subjects, especially the multi-unit well consent form. But I want to remind everybody that if you're presented with a document to sign, today again, we're talking about multi-well or multi-unit well consents and releases, but those are just two documents. If it's a gas lease, people in Tioga County, again, being presented with gas leases when they already have an active gas lease. Again, man, red flags should be flying up all over. Why, when I have a lease, are they offering me a new lease? Is it to benefit me or them? You need to answer those questions. You need to have those answers to those questions. Same thing, though. Again, we're talking about limited documents today, but pipeline agreements, well pad agreements, meter site agreements, any other agreement, the same type of reasoning and rationale applies. Do not rely on the company landman to educate and inform you on what you need to know, because the company landman does not work for you. He or she works for the company. If there's information that would be valuable for you to know, but if you knew that information, you would not sign the agreement that's presented to you, do you think, asking the question, do you think the person who works for the company, who's trying to get you to sign that document, is going to give you the information that would be valuable to you to make a decision, but it would be valuable to you and your decision would be, you know what, I'm not going to sign this document because I don't think it's in my best interest? Are you going to rely on the employee of the company to tell you what you need to know to fully and properly evaluate what is in front of you? Well, that's your decision, but I'm going to say that we need to stop signing bad agreements. We need to stop relying on the company employees or contractors to educate us and represent our interests, because take a look back. All we got to do is look at this history. How many people are jumping up and down saying, oh, this is great. They told me I wouldn't have deductions, and now I don't have deductions, or now I do. Thousands of people in that position. So we need to turn this around. It's this aircraft carrier lumbering along where companies, opinion, take advantage of people because they are not informed and do not have the information and just steamroll right over people. We need to stop that. Stop that. We have to. And the good news is we can stop it. We can stop it by you as the landowner, as the royalty owner, getting somebody that's going to represent your interests, who's going to tell you what you need to know, who's going to tell you what are the important facts and why. Why is a company offering me a new lease when I already have one? Why is it maybe not in my best interest to sign this multi-unit well consent? Maybe. Again, you need specific advice. Why? Why does it matter that I have a well pad on my property that never produced any gas, and now they're going to reclaim that pad and build another somewhere else, and they want me to sign a release? Why may that matter? Those are the questions you need to have answered, and not relying on the company to answer them. Why, when you might be able to obtain 2, 3, 4, or 5 times the money being offered, is the company employee or representative going to tell you that? Why are they? Why are they? Well, look, maybe they are, but maybe they are not. You're listening to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. I represent Pennsylvania landowners, property owners, royalty owners. We do not, have not, and will not represent companies. Companies have enough people working for them, representing them, fighting for them. You need someone fighting for you. So it's a broken record, but I want it to come across because I want to help everybody that we can. As I say, grew up, look on Airport Road, Parks Township, Pennsylvania, Allegheny County. That's where I grew up. So I want to help people like my parents, like my grandparents, like all my rural neighbors in Parks Township in Armstrong County. I want to do that. I want to even the playing field. So I'd love to hear from you. But if you don't call me, call somebody who feels the same way, who wants to help you, who wants to represent you. We have clients and have represented people who are located all across Pennsylvania with property and gas rights all across Pennsylvania, and who reside all across the country, the United States, and even in other countries. So do not be afraid of distance. Give us a call, learn about what we do, and see if we can help you. I say a lot about reviews and consultations. Here's I'll make this a quick war story here. True story, okay? Landowner offered $2,500 one time, $2,500 to sign a document. They called, we did a review and consultation, explained why I thought they shouldn't sign the document. Here we are now. They didn't sign. Here we are now. That same landowner, just over a year later, is literally on the verge of signing a new lease for over $1 million. $2,500, not an acre, $2,500. No, didn't take it last year. This year, on the verge of signing $1 million lease based upon the property. So those are the type of things that I see happen, and that's why I get so emotional and so involved in this, and why I want to do reviews and consultations to make sure something like that doesn't happen to you. Doesn't happen all the time, but it happens. And sometimes it happens like that, like the difference being $1 million up front. And better terms and language and so on and so on. But that's the thing I'm talking about. And that's the thing that kills me, because I know that companies send representatives out to people like they did this gentleman last year. And that person is promised, hey, we're going to get your royalties. This is great, great, great. Get your royalties. Here's my pen. Sign here. The person signs. The person never knows that if they didn't sign, there may be a substantially better opportunity in the future. That landowner never had the opportunity to understand what might happen in the future and how to weigh what may happen in the future with the certainty of today. What are the pros? What are the cons? What are the benefits? What are the detriments? Do I sign or not sign? None of that was ever discussed. And had it been discussed by somebody working for them, they probably would have said, you know what, I'm going to wait because I think something beneficial is going to happen. In this particular case, the company said, oh, we're going to go ahead. We're going to have continuous operations. You're going to be held. You'll never, ever get a new lease. We look at it and say, you know what, not so fast. I don't think so. And we can look at certain things and we can tell, and we can research and determine in this case, no, I don't think that's going to be the case. And weighed the option, held off, wasn't the case, lease expires. Now we got $1 million offer. $2,500 up to $1 million. Not an exaggeration. So that's an extreme example, but that happens and we have to stop that. So give us a call. Clark Law Firm, represent landowners, only landowners, have not, will not, do not represent companies. 570-307-0702. We need to stop signing bad agreements. We need to remember that the company landman works for the company, not you, the landowner. Have a great, great week, everyone.